Hello, everybody. It's Dave Neal. Happy Friday. Bachelor Nation news is full steam ahead. I've got multiple videos in the Clayton Echard paternity scandal. I've also got some other Bachelor Nation news. Kat Izzo talking trash about former fiance. Love to see it. We'll cover that story and much more today. And also this afternoon, Bachelor Rush Hour, the hit podcast. I'm going to cover the Accuser's no-show. That's right, Jane Doe, the no-show on the deposition. It's going to cost her. We'll cover this whole story, look at the court filings, and then I've got another video after this where she seeks, some protection from the public. She would like some of her court documents sealed and her testimony sealed. And I don't know if that's going to happen, as it's pretty much not happened so far, but we're going to get into all of this right now. If you need quick, bite-sized summaries of this court case, I've now dabbled in the TikTok. That's right, your boy Dave Neal, not just power recapper, power TikToker. So on Instagram and TikTok at DNeals, you can go check that out. Hey, it might help support the cause and get seen by new audiences. All right, Accuser no-shows deposition. Let's go into it. I'm going to read the initial sort of legal mumbo-jumbo, and then we'll get to the goods, which will be the sort of correspondence between Janie Dodo's newest lawyer, the old special 12th. It's like you might not have been her first love, but you're her 12th or 13th lawyer. And hey, that has to mean something. You're not just a nobody who would take the case. You are the next person in line. Maybe you can crack it and find that fetal DNA. In the Superior Court of the State of Arizona, here it is, in the matter of Jane Doe petitioner and Clayton Echard respondent, notice of non-appearance at deposition pursuant to Rule 57G. Oh boy, somebody played hooky. All right, respondent Clayton Echard, by and through undersigned counsel and pursuant to Rule 57, hereby notifies this court, we got a tattletale, that petitioner Janie Doe failed to appear at the properly noticed deposition scheduled for January 17th at 1 p.m. Oh, boy. Oh, Woodnick got stood up. Yep, that's right. They were there waiting. They had their fresh press suits on, their nice power ties, and the tea went cold, as it were. Counsel conducted the deposition, was notified the day prior to the deposition that petitioner was not going to attend. Jane Doe and her former counsel, and they put a underscore on the S, and her former counsels were previously noticed and agreed to the date of the deposition on or about December 28th, 2023. Notably, when petitioner obtained new counsel, she did not request an extension of time or otherwise indicate she would not be prepared for the deposition. It should also be noted that petitioner, through her prior counsel, filed a motion to quash the deposition, which is still pending before the court. Respondent provided his response objection on January 4th. No reply was timely filed and no court order restricted this properly noticed deposition. Still, petitioner, willfully attached, failed to attend. The reasons provided by petitioner's new counsel for not attending the properly noticed deposition failed to comport with Rule 57, Arizona Rules of Family Law Procedure. As a result of Jane Doe's failure to attend and failure to adequate provide notice of her non-attendance, respondent has incurred attorney's fees and costs. Okay, so this is costing people some money. Jane Doe's counsel indicated that he will be filing for some sort of request for protective order. As petitioner's most recent counsel was advised in the correspondence attached, this is not valid cause to fail to attend a deposition and does not comply with the rules. The court currently has a motion for sanctions pending. Respondent intends to reference this notice in advance. The consistent arguments regarding appropriate consequences for petitioners' continued noncompliance with the rules. Hey, look, there's so many motions pending. I understand these judges have a lot of other cases, but can we clear the schedule for February? Can we clear the schedule and dedicate 8 hours a day to all of the different motions so we can find out what's quashed? I mean, in my own trial where I'm being sued for harassment, Chase J. Jones has filed multiple motions to quash subpoenas, and it's like, why are we all trying to quash this thing? Come on, I thought we were having a party. I thought we were tickling each other. I thought this was fun. Not that I was the one who did the suing. I was just responding to the suing, but I thought we were playing a game. Are you not entertained? Are we going to quash this stuff? Or are we going to party? Come on. Here are the exhibits. So I'm going to actually go to the back end and work my way forward because that's January 17th. So let's go backwards here to the exhibit exhibits and start with Isabel. Oh, dear, dear Isabel. This is the Isabel from the Valley Law Group, not Woodnick Law's Isabel. It looks like we have a battle of the Isabels. Remember this day, January 19th, 2024, as the Battle of the Isabels. I think it's spelt the same way, too. All right, we love a good Isabel. January 11th, Isabel from Jane Doe's law firm said, "Good afternoon. In regard to the above referenced matter, please see the attached notice of appearance that has been filed on behalf of petitioner Janie Doe. A physical copy will not follow unless otherwise requested. Sincerely, Isabel, paralegal." Well, Woodnick's Isabel, I believe, is a lawyer, not a paralegal. But hey, you got to start somewhere, right, Isabel? Be an Isabel. Just make sure you're on the right side of this story. From Corey, this is Corey, the new guy, not Corey Matthews, not from Boy Meets World, although maybe he became a lawyer. I don't know. I didn't watch the new series. Mr. Woodnick, that's Clayton's lawyer. "I intend to depose Clayton at my office. Please let me know yours and your client's availability on the following dates: February 1st, February 2nd, February 8th. I'll have to look at my calendar. I'm free. I'm wide open on those dates. So I'll be here to cover it regardless of what they choose." And then we get to Greg's response. Greg Woodnick, Clayton's lawyer, sends this to Corey. Corey, and again, we love legal insults. Greg Woodnick may get a Pulitzer Prize for his legal insults. "I am a bit confused, as we were contacted by a different firm, indicating they would be taking over as representation of Jane Doe. Under normal circumstances, I would have brushed that off as maybe wires being crossed. But I think you will be the 12th or 13th lawyer in this melee. So I want to make sure you are not already withdrawing. It has been a pattern here." That's That's Clayton's lawyer saying, "You're just about to run for the hills, ain't you? Here, make sure you get some water. You're going to be thirsty." Regardless, I am just happy Jane has counsel, as it will keep our deposition on Wednesday productive. As a reminder, Jane remiss in her discovery obligations to date. She has provided none, so no discovery per Rule 62. She needs to bring the requested documents to the deposition attached as Exhibit A along with the notice. I'm also happy to resend blank HIPAA releases. They were ignored previously for her to execute. Also, and by the way, of course, she told all of us she's complying and sharing her HIPAA. She never did any of that. Also, as your date request to depose Clayton, of course, we can make that work. And yes, we are available on Groundhog Day, February 2nd. I am just glad to hear Jane agrees that further discovery is critical. So we welcome the formal notice. Please dispatch for the record. I am requesting that we start a bit earlier, 8 a.m. at your office, because it is on a Friday and I have other commitments in the afternoon. Isabel, copied, will be there with me, as in light of your client's history, we don't engage with her without witnesses. Happy to talk offline today if you have a few minutes. Oh, man. Oh, my gosh. Oh, this is like Muhammad Ali fighting a 3-year-old. No offense to Corey here. He has no idea what he's getting into. So Greg says, "I will not be in the same room with your client." Why is that? Why wouldn't you? You're a respected lawyer. "Oh, well, because she emailed the judge." She emailed the judge? Yeah, she emailed the judge claiming I was part of a rape conspiracy. And Greg says, "You know what? I guess because of that, I'll no longer..." It's how wild of it. Clayton, she has an order of protection against Clayton. Clayton's lawyer essentially wants an order of protection against her, in the sense he just doesn't want to be alone with her. Hey, get this. I don't disagree. I wouldn't be caught dead alone in a room with her. I would be holding on to my selfie sticks, live streaming. Hey, here are my hands. I'm up here. You know what I mean? Holy cow. Would I be nervous to be near her? And for good reason. She literally contacts the FBI if her mail's late. You know what I mean? I'm having the FBI look into the fact that my Postmates order is 2 minutes behind schedule. My Uber was supposed to arrive at 7:23 p.m. It's 7:40 p.m. I know it's just after rush hour. A concert was let out, but I think the FBI should investigate where Morton is, because his Prius has not moved that far past. I've been looking at the map here. The Prius hasn't moved, so clearly somebody must be trying to conspire against me here. Okay, all right, we're having fun. There was a hair in my food. FBI, is the chef wearing his hairnet? Okay, here's the response from Corey. Mr. Mr. Woodnick, thank you for your email. After reviewing this case more thoroughly, hi Corey, how are you? You've been watching our YouTube channel. I am writing to request your position on both parties signing a protective order under Rule 53 with relation to the deposition. Okay, so this is the day before the deposition was supposed to take place. Specifically, we will be requesting that the deposition transcript, testimony, and any supporting video is documented as highly confidential and kept under seal. We will also request that the deposition scope is limited to matters relevant to this proceeding. Assuming your client does not intend to annoy, embarrass, oppress, harass, or leak the information, I am hopeful that they would be able to sign this agreement for same and move forward with the deposition tomorrow. Please let me know your client's position as soon as possible. If we are unable to reach an agreement, I will be seeking court intervention prior to my client being present for any deposition. So before we even get to Woodnick's response here, it seems that Corey, the lawyer for Jane Doe, wants this completely sealed. And it's like, look, did Jane Doe want this completely sealed when she sent lies to the Sun? When she emailed people and fought with everyone on Reddit? Was she so worried about her confidentiality when she wrote a Medium article about me? Or how about when she wrote to the judge and accused this lawyer right here of conspiring to rape her? I mean, these are heavy things to talk about, but we have to talk about them, right? So she is queen of wanting what's good for her and wanting to silence what is not good for her. She is queen of that. In fact, it's impressive. If there were an Oscar that could go to somebody so delusional that they want to share their lies but not hear someone else's truth, then it's like, get your formal gear ready, Jane, because you're going to be winning some awards. All right, here's Greg Woodnick's response. My guess is, and I haven't read this because I want you guys to see my initial reaction. My guess is Greg Woodnick doesn't back down. And let's see what we have here on this Good Friday. Corey boy, good Corey. Clayton will not be agreeing to a protective order or filing this case under seal. Your client went to The Sun, People Magazine, TMZ, Reddit, Medium, etc., and continues to post and contact the media to date. Also, it is highly doubtful that you will be able to meet the high burden to have a case sealed. Note, your client already tried this and was denied relief. As you are aware from the pleadings, we will absolutely be addressing the malignancy of her allegations, including her historic prior allegations, as they are directly relevant to her bad faith motivation to file this matter. Note, your client also, whenever someone says note, hey honey, note, okay, never good. Note, your client also repeatedly refers to her prior pregnancies in her emails and text messages to Clayton, which we disclosed. Moreover, her prior allegations are entirely relevant to our motion for sanctions, as she has a history of fabrications, and her playbook in this underlying matter is almost identical. Some of texts read like they are cut and paste from the previous matter. We appreciate that subject matter of fabricating pregnancies is embarrassing, but her responses to the questions are absolutely relevant to the pending action in this court. Your objections at deposition are obviously limited by law. Attempts to terminate deposition because we are asking questions that are directly related to our sanctionable actions, that is obviously your choice. I am fairly confident that the judge is not going to agree with you, and she will be exposed to consequences, including attorney's fees and paying for the reporter costs for yet another deposition so that the discovery process can be completed. I have zero intention of asking questions that do not serve a legitimate purpose. Much of our time is going to be spent confirming foundation issues because your client, after she claimed she was no longer pregnant, insisted on exercising Rule 2. Last, no matter what questions we ask, your client will claim they are meant to harass. I assure you that is not the case. I trust you that she had the opportunity to avoid this by acknowledging that she was never pregnant by Clayton. That offer still stands. Last, this deposition was properly set 3 weeks ago, and I have spoken to 2 other lawyers for her that window. If redacted, is now refusing to participate without her demands being met. It is not only an unreasonable request based on the history here in her publications, but a late one. You are more than welcome to call me to discuss. I appreciate you are in a difficult situation having taken this case in this posture, Greg. So Greg essentially, of course, with way more tact and expertise, says what I was going to say, right? That, of course, she goes to all of these publications and no, we don't want to embarrass anybody with the truth. I'm sorry if the truth is embarrassing. I'm sorry if lying under oath and having all of your credibility shot is embarrassing. I would be embarrassed too if I did all the things that you have done. But boy, pissing off a lawyer, not a good look here, Jane Doe. You know why? Because he seems to want to come after the truth now too. And he's not going to bill himself in that process. You know what I mean? So I think the foundational issues as to the sort of Groundhog's Day like stories here, which by the way, Woodnick put that in there to be like, oh, que convenient. You want to do this on Groundhog's Day, where on 3 separate occasions, she told essentially the same story. Interesting. Now, here's Corey's response. Again, Corey's just doing his job. We don't blame Corey. He's actually pretty good here. Greg, I appreciate your understanding of the interesting situation I walked into in this case. And what he's probably saying here is, Greg, I no longer will be alone with my client either. Yeah, if we could tell you anything, just make sure the closed caption televisions are rolling at all times so you don't face any FBI investigations if, your client doesn't get everything the way she wants it. He says, I know you and I are in opposition on this one, but I hope we can represent our clients with the understanding that we are both simply representing our clients and not take issue with each other for doing so. Let's hope our next case together isn't so contentious. After speaking with my client, we will be filing a motion for a protective order related to both parties' deposition of each other. I will have this filed by the time of the deposition tomorrow. My client will be awaiting further order from the court with relation to this before subjecting herself to, this deposition of her, and she will not be present for the deposition tomorrow. To be clear, this is not my client saying she does not want to be deposed. I believe her motion to quash adequately stated and put notice of this, but instead that the deposition should be confidential to avoid continued embarrassment and annoyance as she has undergone thus far in and outside of these proceedings. In order to allow the court to weigh in on this deposition and request for confidentiality appropriately, she must seek this leave prior to the deposition. Thank you. Greg's response. Corey boy, I appreciate you letting us know that Jane is not planning on showing up to the noticed deposition this afternoon. That said, and as I am sure you advised her in a CYA letter, she is not allowed to simply ignore a properly noticed deposition. In light of her actions and exercising efforts to save financial costs, we are canceling the court reporter. We will include the anticipated cancellation fees required by the service in our cost statement and append it to the anticipated China doll affidavit. Excuse me. Note, we will prepare an affidavit confirming her non-appearance and send you the same after 1 p.m. The matter has been set for trial. She needs to comply with Rule 49. She has provided zero disclosure, notwithstanding you being the third attorney I have communicated with about this FC case. I am sending you again the fetal death certificate form I provided to you yesterday and submitted for the third time HIPAA forms for each of the following providers, 3 different doctors, so we can get the records directly from the source and consistent with her testimony in court already. As I explained to Lexi before she quit the case, we will not accept any records from your client that are not given to us from the providers directly. There is an arts and crafts history here. Fortunately, the old Photoshop queen. Fortunately, Jane herself invoked Rule 2, so she should be more than cooperative with signing releases so we can get the records from the source. I am disappointed, but certainly not surprised that the deposition is not proceeding today. Signed, Greg. And those are the different exhibits. That's it, folks. I mean, is it the most interesting thing we've seen so far? No, but always good to see two very professional lawyers spar, joust, if you will, for their clients. Clayton seems to have no problem honoring his deposition. Maybe he has nothing to hide. Jane Doe, the no-show. Can we say the same for her? For show, no. All right. I'll be back on Patreon this morning with some wicked updates. Patreon.com/Dave Neal. Let's aim to do that at the 10 a.m. Central Time Zone. So 11 a.m. East Coast and 8 a.m. Pacific. Do we have that set? Okay. I'll be live on Patreon then to talk with you guys, and so much more content coming your way. Don't forget, if you want to support me in this channel, go check out TikTok and Instagram and go watch some of the different exhibits we're posting so you can see all of the additional exhibits and content there. It is not sealed. It is public record, and we are sharing it. We'll be back with more right after this.